Hello everyone, welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch. And I'm kicking it off with one from my Aussie pals in Perth. Crikey, we've got a pro se Sheila. I hope you like it. Court with Krissy is now in session.
This is case number MGI 25CR243. Ms. Shannon appears by Zoom from the court laptop, state by Ms. Plashka. And Ms. Shannon appears without an attorney. This matter is set for a formal first appearance. Ms. Shannon, you are charged in a 2-count complaint with the following. Count 1 is possession of methamphetamine. It is alleged that on or about June 23rd, 2025 in Montgomery County, Kansas, that you unlawfully, knowingly, and feloniously possessed a quantity of methamphetamine, a Schedule II controlled substance as designated in Kansas statutes. That's a level 5 drug felony. It carries a possible penalty of 10 to 42 months in prison, a fine up to $100,000, and 12 months post-release supervision. In count 2, you are charged with possession of drug paraphernalia. It is alleged that on or about June 23rd, 2025 in Montgomery County, Kansas, that you unlawfully used or possessed with the intent to use drug paraphernalia, to wit, a smoking pipe with residue, used or intended for use, for unlawful use in storing, containing, concealing, injecting, ingesting, inhaling, or otherwise introducing a controlled substance into the human body. That's a Class B non-person misdemeanor. It carries a possible penalty of up to 6 months in the county jail and or a fine up to $1,000. Do you understand what you're charged with in this case, Ms. Shannon?
Yes, Judge Gitler.
All right. And you are appearing today without an attorney. Did you intend on hiring your own, or did you want the court to consider appointing you one?
I can probably represent myself at this time.
All right. You certainly have the right to do so. There are some admonishments and a couple forms that you'd have to review and sign before you'd be allowed to represent yourself.
Yes.
So what we're going to do is your case is assigned to Judge Reynolds. We're going to put your case on his next docket, which is next week. And we're going to set that in the afternoon so you can appear in person and you can let Judge Reynolds know that you desire to represent yourself at this time, and he can review with you everything you need to know in order to do that. If you do decide that you want an attorney and you want the court to appoint you one, then you can get an application and an affidavit. You can fill that out, return it, and if you qualify financially, we'd be happy to appoint you an attorney. Or if you are not indigent and you have the means to hire your own, you may be required to do so. It's always in everybody's best interest, in my opinion, to have an attorney. But if you think you have the ability to represent yourself, then that's certainly a right that you can consider exercising.
I have law experience out of Australia.
Okay, very good. Then you will see Judge Reynolds next Tuesday. That's going to be July the 8th. And that will be at 1:30. They'll be in person here in Independence. You'll be in the large courtroom across the hall.
Okay. I love your bow tie.
Well, thank you. I appreciate that. Anything from the state, Ms. Plashka?
No, Your Honor.
Okay, we'll see you next week, Ms. Shannon. Thank you.
Next week at 1:30, Judge Reynolds.
You got it.
Is that correct?
That is correct.
Anything else I need to know?
Not that I'm aware of. You're good. You're good to go.
Okay. Thank you very much.
You're welcome.
Person at the jail, what is your name?
James Johnson.
This is the case of the people of the state of Michigan versus James Joseph Johnson, case number 252921FY. We're here for an arraignment. Did you have the opportunity to meet with somebody from the public defender's office today?
Yes, sir, I did.
I have a complaint that alleges that on or about June 30th, 2025, here in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of larceny $1,000 or more, but less than $20,000. It's alleged that you stole an AMIGO scooter that belonged to Walmart. That is a 5-year felony and or a fine of $10,000 or 3 times the value of the property taken. Additionally, the prosecution has charged you with as a habitual third offender. That means that you have at least 2 prior either attempted or completed felonies in your past. That makes the 5-year felony a 10-year felony. Do you understand that?
Okay. I'm just kind of like, yeah, blown away.
So I don't want you to say anything about the case, but my question is, do you understand that based on the information that the prosecution has, that is what they've charged you with, and those are the potential penalties?
Okay, yes, I understand that.
All right. On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to. And you have the right to be stop answering questions. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford an attorney, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment of attorney.
What is your current source of income?
I've only been able to work this last 30 days. I was going to start my job, so at current point it is 0.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a prelim. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that this crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That is where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. Do you understand that?
Yes, sir, I do.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I have received the praxis in this matter. It scores him at a risk level 3. Historically, I show in 06 an NSF check less than $100, in 06 an attempted aggravated assault, in 99 a possession of marijuana, 01 petty theft, 05 possession of marijuana, 08 assault, touch to injure, 08 spirituous liquor in a park, 09 disorderly conduct, fighting, 11 criminal trespass 2, 10 criminal trespass 2, in 10 a false information report ID upon arrest, in 12 theft with a value of $500 to $24,999, in 11 criminal mischief 3 with damage of $500 or more, in 11 criminal trespass 1, in 12 criminal trespass 1, 14 criminal mischief damage $250 to $749, in 14 a criminal trespass 2, in 19 a criminal trespass 2, 18 disorderly conduct, 20 disorderly conduct, 20 criminal trespass 2, 21 assault recklessly injure, 21 assault recklessly injured, 21 disorderly, 20 resist, interfere, arrest by force, 21 criminal mischief, 21 criminal trespass, 22 assault 4 cause fear or imminent injury, 23 a DUI with a BAC of a 0.08 or higher, in 23 driving while a license canceled, revoked, or suspended with a previous conviction. Those are all out of state convictions. Our local record shows an 89 a disorderly, and 90 an open intox, 92 an operating while visibly impaired, 92 an open intox, another open intox in 92, and 93 sell furnish alcohol to a minor, and 93 an open intox, 94 receive and concealing less than $100, and an 89 in MIP. Any comment regarding bond, Mr. Roberts?
Yes, Your Honor. Mr. Johnson does have strong ties to this community. He's staying locally and additionally has family in the area that he's in communication with. Additionally, while he's not employed, he is working on getting more consistent employment and has been working, doing like tree pruning and stuff like that. We don't believe he's a flight risk. Additionally, I believe the court could protect the community with non-monetary bond conditions. We would ask for a PR bond or a low cash bond. Thank you.
When you say he's tree pruning, is that like normal hardwood trees or is that Christmas tree pruning? Do you know?
Christmas trees.
Where he was moving to was going to be the Christmas tree pruning. That's right.
Okay, thank you. Prosecutor's office?
Thank you, Your Honor. The defendant was found in the drive-through at Taco Bell on a scooter that he stole from Walmart. He did admit to officers that he planned on driving it home. There was also, officers saw an open box of bagged wine in the scooter, as well as an almost empty bottle of brandy. There was a PBT done, which was a .171. Given that, I do think, along with his extremely lengthy criminal history, I do think a monetary bond would be appropriate. I would also ask for random alcohol testing as well as no contact with Walmart. Thank you.
Was it reported that he had taken the scooter from Walmart, or did law enforcement just come upon him in the drive-through?
Your Honor, it just states they received a report of a male in the drive-through on a scooter from Walmart.
Okay. Well, Mr. Johnson, despite your rather lengthy criminal history, I do not find that you are a threat to the community, nor necessarily a flight risk. So I'm going to release you on your personal recognizance. You are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Because alcohol is alleged to have been a factor here, I'm going to order that you not consume alcohol, and you'll be subject to random testing. Additionally, you are not to use any recreational marijuana and be subject to random testing. You are not to have any contact with Walmart. Do you understand those conditions?
Yes, sir, I do.
Do you think you can live with those conditions?
Could I ask one thing? Could I still smoke herb because it helps me keep from drinking? I've went so long without drinking and just gave in yesterday. If I could just smoke herb, I can do that, no problem.
Do you have a medical marijuana card?
No.
Then for the time being, I don't want you trading one substance for another. And it sounds like, well, so for right now, I will keep the no recreational marijuana in place. But your appointed counsel will know how to bring a motion if we need to do that. All right.
Okay.
Upon your release, you'll need to come over here to the courthouse to get signed up for testing. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, I do.
All right, thank you. Next arraignment, jail.
Randall Scott Ritchie.
Morning, Your Honor.
Good morning, sir. Go right there at the podium there, and then you'll be on the camera. Good morning,
good.
sir. Are you Randall Scott Ritchie?
I am he. Would you like me to spell that for the court?
No, I can see it here. RITCHIE. You got a ticket for trespass, and I really can't tell much about what this is. It's written under state statute. At 5:01 p.m. on June 9th, you got charged with trespass at Eagle Street and First Street in Burr Oak. Trespass at Burr Oak schools. And traditional trespass, the way this is charged, it's not under state or city ordinance. It's got a 30-day maximum jail sentence and a fine of up to $100 plus costs. How do you plead to that charge?
Your Honor, if I may, before
Yes.
I enter a plea, there's actually two charges of trespassing. They're mirror images of one another. One was on June 9th,
Oh,
and
yeah.
one was on June 10th.
June 9th and June 10th. You're correct. Thank you.
You're welcome, Your Honor. I would ask before entering a plea.
Well, let's wait a minute, because I suspect the prosecutor would dismiss one for a plea to the other. So before we do discuss a plea, we'll ask the public defender to discuss this with the prosecutor and see if they'd be willing to dismiss one of the two charges, which would save you about $200.
Your Honor,
Yes,
if I may,
yes.
I'm not interested in accepting a plea.
All right. Well, then
I litigated this same matter 15 years ago in the federal court.
Okay.
There's no basis for charges. I'd like to enter an affirmative or an absolute defense if I may, Your Honor.
All right. So
If
we'll
you'd
show a
entertain
plea of
that.
not guilty.
Not
Yes.
guilty,
All right.
correct. And maybe we can save the court and a lot of people a lot of time and energy on this matter.
Well, I don't know anything about it. Otherwise, I just read you off the ticket.
They're the same, almost
All right.
identical circumstances.
All right, well, do
I
you-
understand this isn't a fact-based hearing.
All right. Well, do you want me to appoint a lawyer for you or just simply?
No, Your Honor, I'm not going to qualify for a public defender. I'd likely go forward as a pro se litigant.
All right. So you want me to just set up for a trial?
I like the court to entertain an affirmative or an absolute defense, Your Honor.
Well, we don't have that in Michigan. You can present it in a hearing, but you don't say I have an absolute defense and the judge just dismisses it. So I'm just gonna set it for trial, let you present your defense. Set 2 hours. And that wants to represent self.
That'll be a jury trial, Your Honor.
Well, I was gonna set it for a bench trial if you want a jury trial.
Yes, I do, Your Honor.
All right, then we take a little different course of action. We'll set it for last pretrial before jury. When you say you litigated in federal court, what was that about?
I was arrested 2 times for attending school board meetings in the city of Coldwater. And then a civil suit was filed before Judge Quist on a 42 USC 1983 complaint. I believe that decision weighed heavily in
All right.
court as a precedent.
Interesting. I'm not sure it was who wrote the ticket.
You have access to Google, Your Honor, when you're on the bench?
Yeah.
Google, if you would, Your Honor, my name in the city Coldwater, and you'll see the first 3 or 4 responses on there pertain to that litigation.
All right, so this was at a school board meeting?
Yes, Your Honor.
All right.
So if the court would like to tell me how long
Well,
it's
I don't-
trespassed at an
I don't-
event by
I
the
don't-
OMA, I'd like to hear it.
Well, I don't, like I said, I didn't make the charge. Somebody
No.
wrote a ticket. And,
No. But I would
So-
respectfully request the judge not place any restrictions on my civil liberties until I have proper due process. And that,
yeah, you just did. So you can do whatever you want. You can leave the state, you can go on with your life. There's no bond restrictions here. But I'm gonna set the last pretrial before jury for August 7th at 2:00. Like I said, this was written on a ticket. Let me look. Yeah, I don't know what the prosecutor knows about it. You got 2 tickets on 2 different days. There's no police report. There's no affidavit of probable cause. There's no bond information sheet. All I know is what I read on the ticket. You seem very well informed of this.
Your Honor, I put in FOIA request from June 5th to determine who issued the trespass against me. And haven't received responses from St. Joe County Sheriff's Department on my FOIA request. And there have been several since. I'd like to have some information too, Your Honor.
All right, well, you're entitled to. All right, Mr. Ritchie, I'm gonna give you a notice. This could be interesting.
I'm certain it will. It has been thus far.
Good morning.
Good morning, sir. Sorry I'm late. I was doing all my fingerprints.
Well, I knew you were here someplace, but sometimes you don't get here till 8:30, and I'm not sure. This will be set for a Thursday, August 7th at 2 p.m. It will be in courtroom C for a pretrial before jury. Defendant to represent
I'll
himself.
grab it in just a second.
We have this one in advance when there's a jury trial to make sure we have the witnesses, exhibits, jury instructions, that sort of thing all worked out before we actually set it for jury trial. I'm not sure how much the prosecutor even knows about this, other than these tickets got issued. So you and I will both find out more about this by August 7th.
Your Honor, I attempted to speak with somebody at the prosecutor's office and was informed that they can't speak to me at this juncture.
Well,
Prior to today, Your Honor. Has that changed
they
after
can
this
speak to
proceeding?
you- No, they can speak to you now.
Thank you.
You're representing himself. Yes, generally, if you're gonna have an attorney, they can't speak to you without your attorney present. But if you represent yourself, they can speak to you. All right, well, I'm interested to find out what this is about, but it's gonna be a while before we get there.
Will the trial be before you, Your Honor? In
Yeah,
misdemeanor court? Yes.
yes. All right, I'll see you on, did I give him his notice?
Yes, sir.
Yes, sir.
April 7th at 2 o'clock. Any discovery? I'll put entitled to discovery from prosecutor.
You said April.
August 7th, thank you. Don't want to go all around the calendar already. All right, Mr. Ritchie, you're free to go on about your Monday morning.
Thank
you, Your
Honor. It's a pleasure being in your courtroom.
All right, thank you, sir. All right, we'll see where that one's going.
All right, good afternoon. Is this Austin Jean Young?
Yes. Yes, ma'am.
All right, sir, you've been charged in Butler County District Court case number 2025 CR 295. The state appears by and through Mr. Regier. Mr. Young is at the Butler County Detention Facility. You've been charged in count 1 with possession of methamphetamine, a level 5 drug felony, and count 2, possession of paraphernalia, a class B non-person misdemeanor. In count 3, possession of marijuana, and count 4, no driver's license. The highest charged offense is the level 5 drug charge in count 1. The sentencing range for that is 10 months up to 42 months with the Department of Corrections, and up to $100,000 fine if you are convicted. If you don't have person felonies, you probably are presumptive probation and may qualify for state mandated drug treatment. I'm not sure where you're going to fall on the grid. It does depend on your criminal history, but that is the minimum and maximum sentencing range. I'm going to not guilty plea for you on all of these charges. The rest are misdemeanors. The paraphernalia is a plastic container that was holding 4 hand-rolled cigarettes and a plastic baggie with some powder residue. If convicted of that, it carries no possibility of prison time, but it carries a maximum sentence of 6 months in the county jail and $1,000 fine, no mandatory minimums. The marijuana charge is the same. It's a B, 6 months, $1,000, no mandatory minimum. And the no driver's license, is a $50 fine, up to $500, up to 30 days in the county jail. These are all alleged to have occurred on or about the 29th day of June 2025 in Butler County, Kansas. As I indicated, I'm going to enter a not guilty plea for you. I am the assigned judge, and it looks like my next available felony preliminary hearing control is August the 18th at 2:30. That is a ways away. Are you going to be able to make bond, sir?
My family's out of state and everything right now. I definitely could have bond money before the 18th for you, or anything like that. If I could just be released today, so I could, like, I'm going for disability. I just found out some information with my health that is not good.
Okay. How old are you, sir?
I am 33.
Are you currently working?
I'm in the process of going for disability.
Okay. And what is your current source of income?
Well, I've been in the process of going for disability. My parents have been helping me out.
Okay. All right. I'm going to appoint Jim Watts to represent you so that you have an attorney for your next hearing. Recommendation on bond.
Your Honor, if the court is prepared to order a strict no contact order with any illegal drugs, as well as that the defendant shall not leave the state of Kansas, which the state does believe to be appropriate, given the statements are made on the record, the state is prepared to proceed with what it considers to be a low bond of $2,500 cash or surety. This is a case where it would appear that the defendant was identified by law enforcement as the operator of the vehicle and admitted to having multiple items of drug-related paraphernalia inside the vehicle. It would appear that law enforcement successfully retrieved from the glove compartment of the vehicle a white drawstring bag containing a white crystalline substance, as well as at least 4 hand-rolled cigarettes containing grief leafy substance from the center console of the vehicle. Additionally, this is a defendant who the state understands has a history of convictions and diversions that the court may consider relevant. Besides at least 1 prior conviction for a misdemeanor DUI, the state understands this defendant this is a defendant with a history of diversions for both possession of paraphernalia and misdemeanor possession of certain hallucinogenics.
Okay. Mr. Young, I want to make sure that you can make a bond since your initial court date, which is basically a staffing date with your attorney to make sure he has discovery and to announce what direction you're going with your case. So I am going to allow you, since you're local, $1,000 surety bond, which is very low, with the condition that you consume no drugs or alcohol. I would strongly suggest that you go to South Central Mental Health when you get out.
I don't know. I'm sorry. I don't know what that means. The surety bond. I don't understand what that means.
Yeah, you aren't going to be able to sign yourself out, but you'll be able to post the lowest surety bond that we give. So probably for under $150, you'll be able to post bond.
I don't know how I can get that today. Like I have no way of getting that right now. I can't contact anybody. My house is unlocked. My dog's out. Like I just need to get home. I can come back and pay $100 today. I just have to be able to get home.
Usually you can work something out with the bondsman if you show them that you have resources or a number to call a family member or something. So, all right. So $1,000, no drugs, no alcohol. You are not going to get disability if you are using drugs, and you are going to end up in jail if you're using drugs. And that's why I said you need to go somewhere like South Central Mental Health or to some local mental health service that can help you find some drug treatment so that you can be drug and alcohol free to get through this court case and to put yourself in a better position to get disability if that's what you need.
Okay.
All right. Contact Jim Watts when you get out. Stay in contact with your attorney. Make sure that you reappear on August the 18th, 2025 at 2:30 for this case. Thank you.
Thank you, Your Honor.